Hello, good afternoon, everyone. I am Atul Chaudhary, Assistant Professor at IIMT College of Law. And today, our topic that we'll be discussing is General Overview of International Law. So, what we will discuss in this topic today is about general basic introduction of international law, some of the important topics that concerning the international law. Okay, so let's start our lecture. So first, let's talk about the introduction of international law. What is actually international law is, what is the nature of international law, what is the scope of international law. So this is important for us to understand about international law completely, fully, and satisfactorily. So it is important for us to understand about international law, the introduction of it. So for the introduction of international law, let's just look at some major definitions of international law given by some famous popular international jurists. First of them is Oppenheimer. His full name was Lesser Francis Lawrence Oppenheimer. He was a German born, later he became a British citizen. What he said about the international law, what was the definition that he gave about international law? And the definition is international law is the body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. So what he told international law, what he tried to say in his definition about international law is that it is a body of customary and conventional rules which are considered legal binding by civilized states in their intercourse with each other. So from his definition, we can see that international law is some kind of law that is applicable between states. And by here states, it is mean countries. At international forum, it means countries. So whoever the civilized countries, whatever the rules that they follow while they're interacting with each other, while they're working with each other, during their intercourse, whatever the rules the states and countries follows is international law. So it is a body, he told that it is a body of customary rules. Customary rules means rules that have come from custom and long usage, long and continuous usage. So international law, according to him, is made of customary laws, international customary usage, and conventional laws like treaties and conventions. Now we move on to Stark. There wasn't a conclusive picture of Stark available on internet searched everywhere. So his full name was Joseph Gabriel Stark. He was Austrian. What his actually this definition of international law that is presented before us in this slide, this definition was given by Stark in later period. The initial definition of international law given by Stark was very short definition. So just have a look at this definition of international law. It says that the international law may be defined as the body of rules which is composed for its greater part of principles and rules of conduct which states feels themselves bound to observe and therefore do commonly observe in their relation with each other, which also includes the rules of relating to the function of international institutions or organizations, their relation with each other, their relation with states and individuals, and certain rules of law relating to individuals and non-state entities, so far as the rights or duties of such individual and non-state entities are the concern of the international community. That's a quite broad, lengthy definition. And he also in his definition says that the international law is a body of rules which are composed of conduct of state that concerned the rules of international law are concerned for the conduct of states, and states commonly observe these rules, they follow these rules while they're interacting with each other. So in the previous definition of Mr. Oppenheimer, which is an older definition of international law, he just says that civilized nations in their intercourse with each other, that international law is applicable on civilized states only. So what he's trying to say that international law is applicable only on states, only on countries, and only the countries and states are the subjects of international law according to his definition. But now we come to J.G. Stark's definition of international, especially this in definition. It says that states feel bound to follow these rules and they commonly observe these rules. and the rules of international law relating to function of. And now, in his definition, if you look at point A, he also says that the rules of international law relating to the functioning of international institution or organizations. What he's trying to say is, in this definition, according to this newer, fresher definition of international law from Stark, international law is not only applicable on states, but it is also applicable on international institutions and organizations as well. And in later part of the definition, he also says that sometimes individual and non-state entities and actors also become part of international law if it becomes a concern of international community. As you say in the last point, he says that non-state entities are the concern of international community. So the international law can also be applicable to on individuals. It can also be applicable on non-state actors, private organizations. If the application of the international law, it becomes a concern of international law. If it becomes necessary for the international system to work. So apart from state, non-state entities can also be given personality. Non-state entities can also be the subjects of international law if the situation demands, or if the international law starts to take them as such. Now let's come to nature of international law. So what till in the introduction we have known that this is a bundle of rules. It is made of rules. Either they are customary rules or they are conventional rules like treaty and conventions. And these rules are applicable on state when they interact with each other, and not only states but also non-state entities, private organizations are also part and subjects of international law. In very precise statement, if I have to tell you what international law is that law on which the international community has agreed to follow the rules and laws. International law is that law which international community has gathered and agreed to follow these rules and follow or not follow those rules. Okay, so whatever the international community has agreed upon that this is a valid legal conduct that we will consider it is international law, and whatever the conduct they said that it is not acceptable or it will not be accepted as legal, that also become that it all shapes international law. So international communities agreement basically is international law, if we have to say about the introduction in the simplest form. Either that agreement comes in the form of customs, or either that agreement comes in the form of conventions or treaties, whatever it may be. Now it comes to nature of international. What is the nature of international? First, we see that there is no enforceable central authority in international law. The nature of consensual law is international law is consensual, as I told you just before the slide, that whatever international community agrees upon becomes international law. It is not a vertical system, it is a horizontal system of law. Okay. So if we see any positive jurist, be it Jeremy Bentham or John Austin, they are the two most important and impactful positive jurists, I must say. And according to them, international law is not a law. It is just their opinion that international law is not a law, but actually, I'm telling you that international law is a law. But according to their definition and their look, their perspective, their view of law, international law is not law. Why? If we look at Austin's definition, Austin clearly says that the law is something which is given by the sovereign, that is superior, so politically superior to the politically inferior, its subjects, and it is backed by sanctions. But international law does not fit into this tight definition of John Austin of law. That is why he did not agree to call international law as law. Okay, because according to the definition of positives, especially John Austin, there is no sanction or enforcing authority in international law. If you think about United Nations does not have any binding nature. There are lots of resolutions passed against long-range missile tests of India, but United Nations resolutions are not binding. It is up to the state they want to follow it or not. Okay, so there is no central authority in international law. As I told that the nature of international law is consensual. Whenever international community consents to make something legal or lawful or acceptable, it becomes international law. So that is the nature of international law. International law is consensual in nature. It is not a vertical system, it is a horizontal system, it is not a vertical system. What it means that if we see in our local laws, in our countries, for example, India, there is there is a hierarchy of authorities. Like there is a subject, legislature, judiciary, police force, and all these authorities that are in vertical. So the power comes down from the above to the authority below. But it is not like international law. International law, see international law as a horizontal system, that all the states are at the same level and they agree on something to make a law that becomes international. So it is not a vertical system of law like municipal law, it is a horizontal system for states. And all the states are at equal level. That's why it is called a horizontal system. We come to what soft law and hard law is. What you see, hard law is legally binding obligations such as treaty and conventions. So first is hard law in international law means any law that is legally binding. So if India becomes a part of any treaty, India becomes a signatory, that treaty becomes legally binding on India. So it becomes legally binding on India. Non-soft is non-binding agreement or principle that influence the state behavior. So we know what hard international law is. Any law that country become legally binding. Soft international law is any kind of international law or resolution that are not binding, but they somehow influence the conduct of states. It is becomes soft law. Just like Universal Declaration of Human Rights is a soft law. It means it is not binding, but its nature is that the states feel themselves bound to follow it. So it somehow affects the conduct of states. In international, there is a great debate that is, I have discussed that is international law really a law? So some critics like John Austin argue that international law is not real law because it lacks a sovereign authority and enforcement mechanism like any police force or any, there is no international police force. There is Interpol, but Interpol is not an international police force. Interpol is just an organization to share sensitive information between police departments of different countries. However, most modern jurists agree that international law is valid even without central enforcement due to its influence on state behavior and global governance. So, international law is actually a real law. It just does not fit in the definition of positive definition of law. What was Holland's criticism? Holland was also another quite popular positive law jurist. What according to his what was his criticism of international law? This phrase reflects his belief that international law lacks the essential feature of legal, systematic, particular enforcement of sovereign authority, making it more and morally guidance rather than true law and strict jurisprudence. What Erskine Holland used to say, a legal scholar argued that international law is not true law because it lacks a characteristic of a legal system found in domestic law, especially a sovereign authority. According to Holland, international law is akin to positive morality because it depends on the voluntary cooperation of states rather than enforcement legal framework. So what Erskine Holland wanted to say is that international law is just a positive morality on part of countries. What he's trying to say is that if states are willing, then they can follow international law, becomes international law, and then international law becomes enforceable. But if the states do not want to follow international law, it does not become enforceable. So it only depends on the will of the state. Then why should we consider international law as real law? The first is that is widespread application, compliance. many countries, there are many international laws that many countries follow, and they follow it very seriously. So countries follow international. Despite the lack of global enforcing authority, state overwhelmingly comply with international treaties and norms. This shows that international laws influence behavior and promote order. Example is World Trade Organization. Vast majority of countries comply with trade agreements, regulations set by World Trade Organizations. We all know that all the countries follow the World Trade Organization agreements. So international law has widespread compliance. Existence of international courts. There are international courts in international system. It is not like that international law is just does not have any feature of domestic laws. It has its features of domestic laws. Institutions like the International Court of Justice, International Criminal Court, and arbitration tribunals offer a legal mechanism for state and individuals to settle disputes and hold violators accountable. So these are some of the famous courts of international law that adjudicate on international law, and they also establish accountability of people who violates them. For example, the ICJ ruling on territorial dispute like the Nicaragua versus United States case demonstrate that states decide by court decisions to maintain international law and peace credible. Binding nature of treaties. So whatever treaty that a country signs, it becomes binding on it and it becomes international law. Sanction and diplomatic pressure. You know that there is a lot of diplomatic pressure that works on the for the help of international law, and it makes international law binding. And international law also influence the domestic laws, just like European Convention on Human Rights is a convention made by all the European countries, EU countries, to uh, for the betterment of human rights, and that convention has influenced domestic laws of those countries. Now we talk about sources of international law. What are the sources of international law? There is no treaty or convention to talk about and to specify the sources of international law, but there is an article of International Court of Justice statute which says that court will apply these laws in order to settle any international dispute. And that article is Article 38. Article 38 of the ICJ statute. The ICJ is International Court of Justice. It is in Hague, Netherlands. Article 38 of the Statute of International Court of Justice outlines the primary sources of international law that the court applies in its decisions. It specifies that the court shall apply international conventions, international custom, that is customary law, general principle of law recognized by civilized nations, and judicial decisions and teachings of the most qualified publicists or for guidance. This article provides a fundamental framework for understanding the sources from which international law derives its legitimacy. So, what are the main sources of international law according to Article 38 of International Court of Justice? They are international convention and treaties. They are international custom. That means customary international law, and they are general principle of law recognized by civilized nations, and judicial decisions and teachings of the most qualified publicists. So apart from these sources, their soft law also becomes source of international law. Just like just for example, just take this example that Rio Declaration on International and Development sets out principal guideline guiding sustainable development and environmental protection. These were just guidelines, and these simple guidelines have become a source of international law in a sense that they have shaped the forming of other international laws. So somehow these soft non-binding laws have also become source of international law. Also remember that there is a hierarchy in these sources of international law. Means the international convention and treaties are the most important and solidified sources of international law. So if International Court of Justice does not find any uh, treaty or convention for the dispute, then after that they come to customary international law, and even after finding about customary international law, they do not find any customary international law, and there is no treaty convention of law, then they come to the third part, that is general principle of law recognized by civilized nations. And then even they do not find the above three parts, then they come to the fourth, that is let's talk about state law recognition in international. As we saw that international law is a horizontal system, it depends on it is depends on equal states. So what is a state is also important. So suppose in a situation a new country born out of revolution, or it got detached from its original country and became a new country, just like Pakistan became a country. So what is recognition? Is recognition is the formal acknowledgement by one state of the existence and sovereignty of another state or government. It is essential for the state to participate in international community and establish diplomatic relations. Type of state recognition. There are different type of state recognition. One is de facto recognition and one is de jure recognition. De facto recognition, acknowledgement of a state's existence and control over a territory without formally recognizing its sovereignty. This often occurs in situations where the legitimacy of government is disputed. De jure recognition, formal and legal recognition of state sovereignty, granting it full right and privileges under international law. What are the criteria of statehood? To be recognized as a state, an entity must meet the criteria established by Montevideo Convention 1933. These criteria are permanent population, it has to have a permanent population, a defined territory, what are the territories of the state that should be clearly defined, government capacity to enter into relation with other states. So these are the criteria that a state or country has to fulfill to become a state in international law. What is the importance of recognition? Recognition enables a state to engage in international treaties, joint international organization, and establish diplomatic relations. It affects issues like trade, security, and legal standing in international law. Effects of non-recognition. Non-recognition can lead to isolation from international community, restricting access to international trade and participation in international organizations. State may be unable to pursue legal remedies or claim rights under international law. Let's talk about what is extradition. It is also an important topic of international law. Extradition is the process by which one state surrenders an individual to the another state for prosecution or to serve a sentence for criminal offenses. It is based on bilateral and multilateral treaties and involves cooperation between states. Principle of dual criminality. The crime for which extradition is sought must be considered a crime in both the requesting and the requested state. Exceptions to There are certain exceptions to extradition. So on these grounds, extradition of a person will not happen. If that was a political offense, that individual accused of any political crime like treason or sedition, and human right concern, if there is a concern of its infringement of its human rights, that states may refuse to extradite if he accused faces the death penalty. Many European states refuses to extradite individual to the US if there is a risk of death penalty. What is asylum? Asylum in international. Asylum refers to the protection granted by a state to a foreign national who flee prosecution in their home country. It is based on international law and involves providing safety and protection from return to the prosecution. That is non-refoulement. So what is the principle of non-refoulement? The principle of non-refoulement states that if a person comes to a country's borders asking asylum, then that person will, if his case is quite genuine, then that person will not be forced to go back to its original country. There are two types of asylum, that is political asylum and humanitarian asylum. Political asylum is granted to those individuals who are prosecuted for any of the political opinions or their activities. And humanitarian asylum is provided to individuals who are facing threats due to armed conflicts or any natural disasters. So that's all that we have to discuss today for our international law. And thank you for that.